Good evening, everyone. Welcome to Melbourne Law School. I'm Professor Michelle Foster, the Dean of Melbourne Law School, and it is such a pleasure to welcome you to the 2026 James Merralls Fellowship in Law Lecture. I'd like to begin this evening by acknowledging that we're gathering this evening on the unceded lands of the Wurundjeri people of the Kulin Nation, and I pay my respects to Elders past, present and emerging, and extend that respect to all First Nations people who are joining us this evening. Well, this lecture series is named in honour of the late James Merralls, AM QC, an alumnus of our law school, resident tutor in law at Trinity College between 1958 and 1972, and later its dean. Mr Merralls, as many of you would be aware, made an enormous contribution to the Australian legal profession. He joined the Victorian Bar in 1960 and soon after joined Sir Owen Dixon, the then Chief Justice of Australia, as his associate. Mr Merralls was later appointed Queen's Counsel in Victoria in 1974. In addition to his illustrious practice at the Victorian Bar, James Merralls was a reporter for the Commonwealth Law Reports between 1960 and 1969, and then from 1969 its editor until his death in 2016. His dedicated service of 47 years is a record in the common law world. James Merralls' meticulous correction and editing of Law Reporter's draft reports, together with his own reports being models of concision and clarity, provided invaluable guidance as well as specialist education to the reporters over his 40 years of service, many of whom have gone on to high judicial office. Many Chief Justices praised his legal skill, integrity, commitment and public service, with the High Court holding a ceremonial sitting to honour his contribution after his death. Chief Justice Gleeson, at that ceremonial sitting, remarked that his tenure as editor was marked by his professional eminence as a barrister, his extensive legal knowledge, and his personal integrity and commitment. I'd like to acknowledge that our law school hosts this lecture series in partnership with the Victorian Bar. I know that we have many guests in the audience from the Bar, so a special welcome to you as well. I'd like to particularly acknowledge Philip Crutchfield KC, who was instrumental in establishing the James Merralls Fellowship and Lecture Series, and to the MLS Foundation Board, who continue to support this important event in the law school's calendar. A special welcome to James Waters of the Victorian Bar and the MLS Foundation Board, who will moderate the Q&A this evening and close the evening. But now, to introduce our wonderful guest speaker. Our speaker tonight is Rachel Doyle SC, a leading specialist in class actions, industrial, employment and discrimination law and public law, with extensive experience in royal commissions and inquests. Rachel joined the Bar in 1996 and was appointed Senior Counsel in 2009. Rachel was one of the counsel assisting team in the Victorian Bushfires Royal Commission and has appeared for parties in the Esso Longford Royal Commission, the Hazelwood Mine Fire Inquiry, the Hayden Trade Union Governance and Corruption Royal Commission, and the Royal Commission into Misconduct in the banking, superannuation and financial services industry. Most recently, she has appeared for parties in the Royal Commission on Anti-Semitism and Social Cohesion. Rachel has contributed enormously to Melbourne Law School over the years. She's been a previous member of the Advisory Board to Melbourne Law School's Centre for Employment and Labour Relations Law and has guest lectured in the Melbourne Law Masters subject, Royal Commissions and Public Inquiries. She's also the author of Power and Consent, a compelling text on sexual harassment in the legal profession. It is such a pleasure and honour to have you with us tonight, Rachel, to explore whether we have become too reliant on royal commissions to resolve our most difficult public questions. Before I invite Rachel to the podium, just a couple of quick housekeeping matters. As I mentioned, we will have time for Q&A after the lecture, so please start thinking about your questions and you'll be able to put them using the Q&A code there through Slido. I also want to remind you that tonight's event will be recorded and a recording will be available on the website shortly. But now, please join in welcoming Rachel Doyle SC to the podium. Thank you, Rachel.
Thank you and good evening, comrades. Now, who are the potential junkies to whom I address this lecture? There are three: politicians, the media, and some lawyers. First, to politicians. Recent royal commissions have served vital purposes, including revealing the causes of disasters, both natural and man-made, exposing institutional failures, and facilitating cathartic and instructive storytelling in public by victims. Royal Commissions have made hundreds of recommendations directed at a vast array of policy areas, many of which have inspired significant change for the better in Australia. Royal Commissions have come to play a very high-profile policy advice role in our country. But my lecture poses this question: have our governments and our politicians become addicted to calling Royal Commissions? Do governments sometimes establish them in order to do no more than contract out the hard questions and the difficult policy decisions to lawyers and retired judges who conduct polite hearings in air-conditioned rooms in Sydney and Melbourne? To the media, Royal Commissions are easy to follow for media and for live bloggers. There's very little turgid debate about the law in a Royal Commission. And at a time when much public discourse is conducted via social media, an inquiry presided over typically by a retired judge does at least provide reputable source material, discussion of which is often better informed and more disciplined than unmediated posts on a Reddit thread. Live streaming of hearings, as I'll discuss during my lecture, has had a number of benefits, including ensuring that the proceedings of a Royal Commission are open to a wider audience, and perhaps even building trust in the work that they do. But tonight I'm going to ask this: have the media and the public become addicted to the ease with which live-streamed hearings can be consumed and reported upon? Is there a risk that the regurgitation of snippets from the daily rolling coverage is now taking precedence over more mature reflection delivered at longer intervals? And have we given up engaging in rigorous assessment of all policy options? Have we given up on constructive criticism of the findings and recommendations of Royal Commissions? The third cohort I address tonight are lawyers. Many lawyers gratefully seize upon the findings of Royal Commissions and inquiries. There are two principal examples. Plaintiff law firms often use the reports of Royal Commissions as fertile source material to plead a class action, and regulators and their legal teams might receive additional funding to assist with investigating and prosecuting cases, the subject matter of which has been traversed at a Royal Commission. I'm going to be warning those lawyers that there are some traps for young players here. I'll be discussing the limits on using material produced to Royal Commissions in subsequent proceedings, and I'll be discussing a more subtle trap, namely the lazy reliance on Royal Commissions as the only source of potential class action inspiration. My remarks tonight are the result of spending 30 years at the bar and of this: my professional life has been directly and profoundly shaped by a number of Royal Commissions and inquiries. Some of them I appeared in, others simply intersected with legal proceedings in which I was briefed before, during or after the Royal Commission in question. I'm conscious of the fact that while my perspective benefits from insights which are the product of having worked directly on these matters, my perspective might also suffer a little from being insufficiently zoomed out or even infected by a degree of burnout. But nevertheless, I hope there's something useful and new that I can share with you about Royal Commissions and their intersection with legal proceedings. Now, some tin tacks. Royal Commissions, what are they? My remarks tonight are directed at Royal Commissions, but also all public inquiries and bodies of that type. They are typically ad hoc, non-permanent, issue-specific bodies appointed to inquire into an event, a disaster, perhaps even a social or political phenomenon. They are appointed by executive government in practice upon the issue of what are called letters patent by the Governor or Governor-General on the advice of government. But each of our states and the Commonwealth now have empowering legislation that govern a great deal of the way in which they operate. Critically, Royal Commissions and inquiries operate pursuant to terms of reference which set the scope and the subject matter for inquiry and consideration. The good thing about terms of reference is that they are easier to read than labyrinthine court pleadings. I'll tell you a little about the selection of commissioners and those who conduct Royal Commissions. These days they are typically a retired judge. For some commissions and inquiries there will be a panel comprised of people with legal and non-legal backgrounds. My observation is that this panel approach is sometimes driven by a desire to have subject matter experts involved and/or to see representation of particular interests or interest groups on the inquiry or commission. Other times it represents a compromise of those matters. Royal Commissions are always tasked with producing a report. It will contain findings and recommendations, which is ultimately produced to the executive government but made available to the public. A habit has developed of requiring Royal Commissions to issue quite rapidly an interim report, followed by a longer, fuller report, usually 12 or 18 months after the interim report. This made a lot of sense. For example, in the 2009 Bushfires Royal Commission, which I'll speak a little about later. We were racing against the clock as the next bushfire season loomed. This habit, though, I've noticed now risks becoming an unnecessary burden for some Royal Commissions where that urgency does not pertain. And the Commission finds itself obliged to rush out an interim report while still working on and adducing evidence or gathering evidence for the fuller report, due often only some 12 months after the first one. I said something about terms of reference. I just want to say something more about that. These used to be relatively brief documents, which acted so as to delineate the outer boundaries of relevance, which was pretty strictly observed in the early days of Royal Commissions. These days, like many written things, terms of reference tend to consist of many paragraphs with a long preamble. Sometimes the length and complexity of terms of reference is the result of an attempt to meet the expectations of many interest groups. The result of that can be a clever compromise or can risk drifting into word salad territory. I want to show you two examples, or talk to you of two examples. If we compare terms of reference in relation to a single event disaster, say an explosion or a bushfire, they are often likely to more closely hew to examining the causes of the event and then exploring changes which might prevent it happening again. When the terms of reference are attempting to grapple with a phenomenon or a greater systemic failing, they can often be more complex and hard to unpick. For example, the terms of reference for the inquiry into institutional sex abuse was long, but useful because it served the purpose of directing attention to the real priority, which was children. One of the paragraphs said this: "It is important that claims of systemic failures by institutions in relation to allegations and incidents of child sexual abuse and any related unlawful or improper treatment of children be fully explored." There was another paragraph that said this: "It is important that those affected by child sexual abuse can share their experiences to assist with healing and to inform the development of strategies and reforms." This is a very good example both of the subject matter and of the approach that the government desired be taken. Can I contrast that with the Banking Royal Commission, where the preamble, in my humble opinion, drifted a little from the traditional function of outlining the outer limits of relevance towards engaging in some pretty explicit foreshadowing of the desired conclusion. Here are two paragraphs for you. "Whereas Australia has one of the strongest and most stable banking, superannuation and financial services industries in the world, which performs a critical role in underpinning the Australian economy," and a few lines on, "and Australia's banking system is systemically strong, with internationally recognised and world's best prudential regulation and oversight." Fear not, Commissioner Ken Hayne did not feel constrained by the terms of reference. Now, what does a Royal Commission do? Well, Royal Commissions and inquiries do not exercise judicial power, which means they do not determine controversies between parties. Rather, what they do is exercise an inquisitorial function. They obtain information and they hear evidence. They have compulsory powers. They can compel attendance by witnesses and compel the production of documents. Indeed, the issue of a notice to produce has become a key tool in generating vast databases of documents. A practice has developed wherein counsel assisting often now pose questions, typically in writing, to the major parties who are affected by or who have something to say in a Royal Commission. They'll often pose a set of questions, something like a set of interrogatories, and seek the production of witness statements answering those questions. Now, this began its life as a vital efficiency, and it certainly has that result. But one of the downsides is that the recipients of these letters are invariably legally represented and then use the opportunity to prepare a pretty dry set-piece statement, very much assisted by lawyers. That may, in some instances, tend to obscure getting to the heart of the matter and may ironically lead to the production of a very long document, the opposite of efficiency. If you attend a Royal Commission or watch a live stream, you'll see they look a lot like a court, but without robes. And that's for a lot of reasons, including the solemnity of the occasion, evidence is given on oath, but also because parties are now typically legally represented. And frankly, it's because of the habits and muscle memory of the participants. As I said, the Royal Commissioner will usually be a retired judge, and counsel assisting in all major parties will be represented by barristers. Despite looking a lot like a court, Royal Commissions are not bound by the rules of evidence, and commissioners can fashion their own approach to the hearing, which I'll say something about in a moment. There's another important difference between Royal Commissions and proceedings in a court, of course. The legislation that establishes and governs Royal Commissions in this country typically significantly abrogates certain common law privileges, legal professional privilege, and in part the privilege against self-incrimination, and also makes some changes in relation to public interest immunity claims. This has no doubt contributed to the success of past Royal Commissions in uncovering illegal and corrupt behaviour, because it enables a broader range of documents and evidence to be adduced. In addition, Cabinet and other high-level policy documents that are typically shielded from production and certainly shielded from being tendered in evidence by a claim of public interest immunity are now typically produced to the Commission, and then the Commissioner will make their own decision about whether or not they will lift the veil and have regard to the contents. This can, however, lead to a frustrating phenomenon where the Commissioner and perhaps some members of the counsel assisting team have seen documents which others do not, and it can lead to the publication of confidential or heavily redacted volumes of the final report, which serves only to tease but not educate. Now, rights of audience. Applications for leave to appear are made to Royal Commissions by parties and groups who want to be heard. A grant of leave is controlled by the Royal Commissioner. The Royal Commissioner decides who will be granted leave and may do so either generally or on the basis of a grant of an entitlement to appear on certain occasions in relation to certain hearing blocks, or perhaps even restricted to being permitted to cross-examine particular witnesses. This means that the capacity of the Royal Commissioner to refuse or grant leave to appear can have a very dramatic impact on the course of the hearing, because it affects who has the right to cross-examine and who has the right to be heard. Parties and witnesses before Royal Commissions will find that they are supplied an opportunity to be heard, at least in one respect. They are always given the opportunity to be heard if there's any prospect that an adverse finding might be made against them. The Victorian Act enshrines this right, and the way in which this is now typically discharged is the counsel assisting team will circulate draft findings to those who might be affected by an adverse conclusion and give them an opportunity to comment before any report is issued. Now, I've mentioned counsel assisting. In modern times, they do tend to take on the role of effectively running the show, and they do the bulk of the leading of all the evidence and effectively a first run of the cross-examination. If you are at a Royal Commission appearing for a party, though, you have a much more limited and reactive role. In typical litigation, you'll proof witnesses and make all sorts of forensic decisions about whether you call a witness or not. You absolutely lose that control and you lose that capacity if you're appearing for a party in a Royal Commission. It is the Commissioner and counsel assisting who call the shots. I should note also there's only a limited capacity for judicial supervision or supervision by the courts of Royal Commissions and inquiries. Legislation typically provides for the referral of questions of law to the Supreme or Federal Court, but that happens rarely. There is one exception to this. At both state and federal level, some aspects of the work of a Royal Commission is always amenable to a judicial review application, but usually only on the grounds of bias or a clear denial of procedural fairness. But here's the critical point. There is no merits review of the findings and recommendations issued by Royal Commissions. You can't appeal their findings, you can't overturn their recommendations. Royal Commissions, as I've mentioned, also now use a range of different processes, often moulded best to fit the subject matter of that Royal Commission. There will typically be public hearings, divided into blocks addressing issues or case studies. But there are now often variations on this theme. Sometimes there are consultation rounds before the hearings, held in public or private or small groups. There will be submissions and opportunities for submissions along the way, addressing particular hearing blocks. Commissions now often use a variety of ways to invite and assist people to tell their stories as well. Sometimes particularly difficult or traumatic evidence is given in closed session, or even in a very small group with a commissioner or a member of the council assisting team sitting with a victim. I'll give you an example from the Bushfires Royal Commission in 2009. At that time, we adopted what was then, I think, a new approach. Prior to the public hearings commencing, there was a series of community consultations held all around regional Victoria, where in community halls and similar buildings, the communities who were so recently fire ravaged were invited to talk and have a cup of tea and brainstorm the ideas and themes and problems that they wanted to be the subject of the various hearing blocks. And that work helped us to prioritise the topics that would be the subject of case studies and further hearings. That Royal Commission was also run with two courtrooms, one bigger room that looked quite like a traditional courtroom, where the various fires and big themes like arson, controlled burns were pursued in open hearing. There was a smaller room, courtroom 2. That was a quieter and distinctly sadder room where we effectively conducted 173 mini-inquests. The former were live streamed, the latter were not, for obvious reasons. There are other examples, and as I've mentioned in the Royal Commission into Institutional Responses to Sex Abuse, there were a number of private sessions held with victims. There's a trend towards most Royal Commissions being live streamed now, and when I joined the council assisting team in the Bushfires Royal Commission in 2009, the question of whether to live stream proceedings was relatively new. It certainly wasn't assumed that that would happen. There were some good reasons to do it. It was good for the victims, many of whom, and their families, many of whom lived in regional Victoria and wouldn't want to come into the city and couldn't face it, given the task they had rebuilding their communities. It allowed many more to watch than could be accommodated in the hearing rooms, and the public interest was obvious. But I must say I saw downsides, and I continue to see downsides, having appeared in a Royal Commission as recently as 2 weeks ago. There is a risk that it is very invasive of the privacy of witnesses, and that their remarks are broadcast more widely and often than would be the case if it were a traditional hearing. There is a risk that some people tailor their evidence to the broadcast. And there is something else that most people seem distinctly uninterested in, but that is the toll on counsel. When I was a young barrister, I had signed up to a difficult job, 18 months working on the Bushfires Royal Commission. I had not signed up to be filmed doing my work every day. I found it relentless and stressful. And the live streaming function has created an atmosphere in which some counsel assisting and others who appear for parties become minor celebrities. This makes us fodder for criticism and even dangerous threats via tweets, Reddit threads and the like that mercilessly comment in real time on our work and the evidence of our clients. Turning to findings and recommendations, there's very little appetite or tolerance in current Australian society for criticism of the findings or recommendations of Royal Commissions. In a sense, that's no more than a very wise restraint. But a typical pattern now is that after a Royal Commission, the government which established it will issue a statement to the effect that they are currently considering all of the recommendations, and short time later they'll meekly announce that they accept all of the recommendations in principle. That phrase often does a lot of heavy lifting. And they will then direct attention to a website where their progress at implementing those recommendations will be tracked. But the court of public opinion rarely ventures to suggest that any findings may have been different, had additional evidence been adduced, for example, or that recommendations might be better crafted if another point of view were now listened to. It can't be that the findings and recommendations are always beyond reproach, and it seems to me that there are surely instances where, at least on mature reflection, the findings or recommendations of a Royal Commission are not perfect, and those with expertise in policy development or in policy implementation may have something very useful to say in the short or the longer term. I'll mention one other phenomenon in that regard. one thing that came out of the Bushfires Royal Commission was the introduction of a new statutory appointment, the Bushfires Royal Commission Implementation Monitor. And that gave a person whose office was established by statute the function of rigorously auditing when, whether and how recommendations were implemented. That may also be a very useful thing to do in relation to recommendations of all sorts of Royal Commissions. Now, intersection with other proceedings. By their nature, Royal Commissions and inquiries might inspire or give rise to criminal investigations and charges, civil penalty actions by regulators, and civil claims by victims, including class actions. There is, however, low public literacy about the use to which evidence adduced in Royal Commissions is actually able to subsequently be used in these fora. It's not well known, for example, that there are provisions in state and federal acts which restrict the use to which information supplied to and evidence given at Royal Commissions can be used in subsequent proceedings. And of course, a very careful demarcation must be observed if there are any pending criminal investigations or charges. And there really are some traps for young players here. I've seen pleadings and witness statements in the wake of Royal Commissions which pay too little attention to these rules. For example, in the wake of the Coate inquiry set up in Victoria in 2020 to inquire into failings with respect to the hotel quarantine program during COVID, a class action was issued seeking to recover economic loss alleged to have been suffered by retail and hospitality businesses. I can't, or I shouldn't say too much, I acted for the state government in those proceedings, which are all but finished. We're about to have a settlement approved. But in 2021, my clients brought a strikeout application against the plaintiffs on the basis that many bases, but one of them was that large parts of the pleadings were simply cribbed from the Coate inquiry report, and that there was a clear infringement of the Victorian Act prohibiting that being done. And His Honour Justice Dixon, in a decision in 2021 in the Victorian Supreme Court reports at 785, said exactly that. His Honour said the evident purpose of that prohibition is to ensure that witnesses at inquiries are at liberty to give full and complete evidence. And so His Honour ruled that the approximately 73 references to witness statements in the statement of claim be struck out and replaced. I want to turn now to some examples from my experience at the bar of either appearing in Royal Commissions, a couple of which I've already mentioned, or appearing in litigation that intersected with Royal Commissions. And tracing my involvement will illustrate some changes in this arena and some examples of the issues I've pointed to. The first Royal Commission I appeared in was the 1998 Longford Royal Commission. For those of you who were alive at the time will recall it, there was a massive explosion, 25th of September 1998. This industrial accident killed 2, injured 8, and the gas supply to this state was cut off for months. A Royal Commission was established only a few days later on the 12th of October. So Darryl Dawson, for whom I had previously worked as an associate, was the commissioner sitting with an expert engineer. The hearings kicked off within a few weeks in November of that year. They concluded in April 1999. His Honour squeezed in 53 hearing days between those two events. And he reported, or issued his report in June 1999. If you go back and look at it, it is an extremely efficient examination of the causes of that explosion, and contains a set of recommendations about how to better regulate hazardous facilities in this state. I appeared at that Royal Commission as Junior Counsel for Trades Hall. Later, I was briefed by the plaintiffs, who were businesses, stood-down workers and domestic consumers, who'd been affected by the interruption to the gas supply. And I was briefed in a 3-month class action conducted in the Supreme Court in front of Justice Gillard. Now, the focus in that piece of litigation was a tort claim seeking to recover economic loss, and in many ways very distant from the explosion. But nevertheless, His Honour's rapid excavation of the causes and the findings were an obvious inspiration and important piece of evidence in that case. I've already mentioned the Bushfires Royal Commission a number of times. My task there was as counsel assisting. It was a gruelling Royal Commission, and we were the subject of intense media scrutiny. But there were two significant impacts which flowed therefrom. The first was a number of very significant policy changes in relation to emergency management and fire preparedness, which I think to this day have put Victoria in a better position in meeting bushfire seasons. Secondly, there are a number of class actions which were pursued in respect of a number of those fires, or at least those which it had been found had started as the result of deficiencies in the management of our electricity power assets. I also appeared in the Trade Union Royal Commission conducted by Commissioner Hayden in 2014 to 2015. My role couldn't have been more different. I had a small set piece, a cameo if you like, a very short appearance for the Plumbers Union in relation to one case study. In other case studies that came before the Commission, Commissioner Hayden recommended that the ACCC prosecute the CFMEU for criminal cartel conduct and that the union regulator take action against another union leader over issues pertaining to signing up members. Now, I was briefed in both of those cases. One required me to defend the ACT branch of the CFMEU in a criminal committal in Canberra, and the other was a civil penalty matter run before a judge of our federal court for a former union secretary. That brought home to me the reality that you may have a very small role in a Royal Commission or none at all, but the after effects may linger for those whose work is the subject of the case studies. Some of you will no doubt recall the Commonwealth Royal Commission into the Home Insulation Program, sometime called the Pink Bats Royal Commission, conducted in 2013 to 2014. I had no role in that Royal Commission at all. But in the wake of it, in 2017, I was briefed for the Commonwealth to appear in the class action that was inspired by that Royal Commission. It was called Roofing, and it was heard in 2019 in our Supreme Court. The pleadings again drew heavily on the Royal Commission's evidence, but managed to avoid the prohibitions that apply. The case ran for 3 months. The group members were businesses that had expanded or commenced installing pink bats or roof insulation, who said they lost profits when the scheme was abruptly cancelled following workplace deaths of installers. It was a fascinating case, and the court's decision confirms that my client, the Commonwealth, did not owe any actionable duty to take care to avoid economic loss to those businesses. The trial was an interesting replay, if you like, of some aspects of the Royal Commission during which a number of politicians and policymakers had given evidence. While my client, the Commonwealth, had initially studiously avoided any analysis of the merits of policy, and you'll recall the policy was to subsidise the installation of pink bats on the basis that it would be good for two things: to stimulate the economy during the global financial crisis and because of the environmental benefits. We had been studiously ignoring engaging in a policy debate, or the merits of policy debate. But partway through the trial, due to some sort of spicy amendments to the pleadings, the question of why the program had been introduced came into the frame. That inspired my opponent, who is now a Supreme Court judge, to summons to give evidence one Mr. Kevin Rudd, who at that time was living in New York City. He gave evidence by video link. He was asked this question: "You were the Prime Minister of Australia from 3 December until 24 June 2010, and again from 27 June 2013 until 18 September 2013, correct?" Mr. Rudd said, "That's correct, and I still have the scar tissue to prove it." In response, or perhaps retaliation, I then called Ken Henry, who had been the Treasury Secretary at the time, and Lindsay Tanner, who had been the Finance Minister. The evidence from all three former members of Parliament, or of the high table in terms of policy development, their evidence was fascinating. And we skated very close to discussing cabinet deliberations, but did manage with some impressive chicanery to just avoid that trap. Crown Casino also gives rise to an interesting example of cross-fertilisation. Well prior to Commissioner Bergen in Sydney being appointed in January 2020 to conduct an inquiry into Crown's fitness to hold its gambling licence, I was part of a team that had commenced a class action in Melbourne, indeed years earlier, in December 2017. We brought proceedings in the federal court in respect of the impact on Crown's share price when its entire marketing team was arrested in China for, spoiler alert, the fact that gambling is illegal in China. We did not have the benefit of a Royal Commission. We simply relied on publicly available material in relation to the arrests of certain Crown Casino staff, and we pleaded out our cause of action. Our proceeding had been going to run in 2021, but that hope was scuttled due to the intervention of COVID problems and shutdowns, which were more difficult in Melbourne than in Sydney. It was during that lockdown hiatus, while our trial was on hold, that the Bergen inquiry was conducted under the bespoke New South Wales legislation, the Casino Control Act. And the China arrests were a case study that Commissioner Bergen inquired into. Now, ultimately, we settled that class action for $125 million in April of 2022. But while the trial was still listed, I was able to watch online many of the people that I was going to be cross-examining in the federal court had our trial run give evidence. Their performance in the Royal Commission may be a reason why we settled at the courtroom door. I want to mention robo-debt. It was a very important Royal Commission. The first class action in that, in relation to robo-debt, commenced before the Royal Commission and was pursued on behalf of those terribly affected by the scheme, and it was settled before the Royal Commission was held. Then the Royal Commission was conducted, during which additional documents, which had not been discovered in the first class action, were revealed, shedding light on the degree to which there may have been misfeasance in public office. So an application was brought by the group members to overturn the settlement of the first class action, reopen it, and run it again, in part in reliance on materials uncovered in the Royal Commission. I had no role in either the class action or the Royal Commission, but recently, when the second class action was sought to be settled for a record $470 million in compensation, I had a bit part before Justice Beach, having been briefed to appear for the litigation funder seeking to have its commission paid. That robo-debt Royal Commission is indeed a very important example of a Royal Commission which changed things significantly, both in terms of the knowledge that the public came to have about what had taken place under that pernicious scheme, and in directly affecting the course of the litigation which had been brought to vindicate those who had been harmed by it. That is a scattergun list of Royal Commissions that I've been involved in or affected by. And you will see that over the 30 years of those Royal Commissions, they have provided much fodder, and some might say even essential nutrients, perhaps superfoods, that have sustained my professional life. Maybe I'm too close to the subject matter, but with the benefit of those experiences, I want to offer a couple of additional observations. I want to say something about trust. There haven't been any longitudinal surveys or studies of public confidence of Australians in Royal Commissions, whereas we have had quite robust studies in relation to courts and the way that Australians view them. As has been noted by the Honourable Master Neve in an article published in the International Journal for Court Administration in 2021, the article is called "Building Trust, Can Courts Learn from Royal Commissions?" The author suggested that it's probably legitimate to point to the fact that in Australia there's often intense public pressure on governments to establish Royal Commissions, and that might stand as evidence of the fact that Australians have a high degree of public confidence and trust in Royal Commissions. That may be so, but I want to, so we trust them, but I want to ask this: do we need them? I think that Royal Commissions do serve a very important function, especially when investigating disasters, something they're very well pitched to do. Royal Commissions and inquiries are also very effective in exposing systemic failures by governments and large institutions. Robo-debt is a fantastic example of that. Further, because they're not hampered or hamstrung by the rules of evidence, such as those which constrain the use of similar fact evidence in court, what Royal Commissions can do is look at the experiences of many and then synthesise those results in a really important way. The Royal Commission into Institutional Responses to Sexual Abuse is one of the most important examples of that. The crimes committed by priests and others who had hidden those crimes had been deliberately and expertly hidden by the leadership of organised religion for hundreds of years. There was immense value in the public exposure of those evil crimes and corrupt cover-ups, which rot our religious institutions from the inside out. and there was a profoundly cathartic experience inherent in the process of victims' stories being told and heard in public. So that is a very good reason to continue to conduct Royal Commissions. But another reason why Royal Commissions have proven so useful is that when there are many who are the victims of a particular disaster or the victims of a certain institutional failing, Royal Commissions don't impose the individual on the burden on the individual to marshal all the resources that you would need to run civil litigation with all the risks that entails, personal and financial. And because of these and other experiences, I agree it is rational for Australians to trust and rely on Australian judges and lawyers to forensically slice and dice, to synthesise voluminous information and to make useful recommendations about difficult problems. I do think that the vast majority of Royal Commissions that have been conducted in the last 30 years have been of enormous educative and practical value. So it is rational for politicians, the media and the public to put a lot of trust and faith in Royal Commissions and inquiries, and it has tended to be handsomely rewarded. But, there's always a but, I want to say 4 things to the governments who establish Royal Commissions. First, sometimes we already know the answer. Secondly, Royal Commissions are sometimes too slow and the problem at hand is too serious and too urgent to spend the 18 to 24 months it's going to take. Thirdly, they are not the only way to find things out. And fourthly, they're not the only way of developing and changing policy. Can I just unpack those 4 things briefly? The first I mentioned was sometimes we already know the answer. In late May this year, the Prime Minister was tackled on a radio program in Hobart, and it was put to him that the government should immediately accede to demands for a Royal Commission into femicide and family violence. The Prime Minister was somewhat dismissive. He said there are always calls for Royal Commissions about everything. He said Australians know what caused domestic violence and what the solutions are, and he said we need to get on with action when it comes to these issues. Indeed, family and intimate partner violence has been the subject of inquiries in Victoria and South Australia and the subject matter of many inquests, including one I appeared in. I appeared for Ms Rosie Batty in the inquest into the death of her son Luke. Each of these inquiries and inquests have heard from experts in the field and given much time to victims and explored from the perspective of the police, the court system and the victims what we need to do. I agree with the Prime Minister on this one. We don't need another inquiry on this topic. We just need to continue to fund police, courts and specialist agencies to implement the recommendations that have already been made. I suggested that Royal Commissions are sometimes too slow. They are. They privilege meticulous and time-consuming inquiry, investigation and introspection over immediate policy decision and action. Sometimes that's appropriate, but I venture to say sometimes it's not. Is polite parrying in courtrooms in our capital cities the only way to do things? In my view, sometimes what's needed is not an inquiry, but decisive action. Sometimes this reliance, this over-reliance on one tool in the kit bag, let's send this problem off to a series of hearings in Melbourne or Sydney, feels a little bit like that Monty Python style sketch where there's a serious problem which calls for immediate discussion. Sometimes what the government needs is not a former High Court judge on speed dial, frankly. What it needs is the spine to seize the moment and announce a significant policy shift, legislative change and a budget reallocation. And that spine is sometimes sadly lacking. The third suggestion I made is that Royal Commissions are not the only way to find something out. I'll put it by way of a question. Why do we assume that the only thing that our political leaders will listen to is the megaphone of evidence given under oath at a Royal Commission hearing followed by a report tabled in Parliament? When something goes wrong, if there were less of a culture of fear and less of a fear of litigation, public servants and leaders and managers of large institutions might more nimbly take part in internal reviews. And if those reviews were less punitive exercises and less defensive and more in the nature of a real and genuine debrief and an opportunity to find solutions, there are many situations where the solution would come from that process rather than necessitating a Royal Commission. The fourth point I made is that Royal Commissions are not the only way to change or develop policy. Sometimes when the hearings end, the report's written, the recommendations are published, the purpose-built courtroom's been mothballed, you can be left wondering, was that Royal Commission the only way we could have arrived at the recommendations which have just been made? Before the mania for establishing Royal Commissions had fully taken hold in Australia, the way that complex problems requiring policy solutions were tackled didn't always default to a Royal Commission. The public sector was known, right up until the 1990s at least I'm sure, for having recognised skills in developing policy options for serious consideration and debate. The thing is, we don't elect our government solely to be a conduit of terms of reference for successive issue-based inquiries. We elect them to govern. This ought to involve consulting widely and then developing sensible policies, even when it's difficult and unpopular. And it is not the case that a policy is only a good one if it's been through the meat mincer of a Royal Commission. I close with a couple of observations to the other cohorts of junkies, the media. There are many good reasons why Royal Commissions are regarded as a trusted and sometimes entertaining source of fact-finding and intelligent suggestions about how to avoid past mistakes. But I do fear that Australians and Australian journalists have become too reliant on the self-soothing exercise of watching from the comfort of your laptop or your iPad at home the live stream session of a Royal Commission. One of the problems with the rolling coverage on this day-by-day granular basis is that while it can be very entertaining, the media ought also bear in mind the need to do the zoom out at the end and look at the pieces of the puzzle all together. The media should engage in a fair and robust analysis of the findings and the recommendations. This is sometimes all the more important when the findings will never be subject to appeal or being overturned. To lawyers, my third potential cohort of junkies, I suggest you ought not just rely on Royal Commissions and inquiries as the only way to vindicate rights for your clients. Certainly Royal Commissions are an essential food source. They might even be the best macronutrient in this domain. But they're not the only source of information. You don't need a Royal Commission to inspire you to help someone. You don't need to sit in a room waiting for the report to be handed down, to turn it into pleadings. You can get out there, you can speak to victims, you can find the whistleblowers. That can be how you start your pleadings. I close by asking this: are Royal Commissions useful? Almost always. But are they essential? It's more rare that that is the case. Like any drug, we need to titrate the dose to find the right balance between therapeutic benefit and dangerous side effects. And we must always ask whether our righteous anger over a particular event or disaster should instead be harnessed to reject traditional medicine and immediately embrace alternative therapies, or even to rapidly schedule drastic surgery. Thank you.
Thank you, Rachel. My name is James Waters. I'm a barrister of the Victorian Bar and also a member of our Melbourne Law School Foundation Board. I'll hold my thanks and your thanks for Rachel just for a minute. I want to say two things. It gives me great pleasure to be here tonight as part of this collaboration between the Bar on one hand and the Academy on the other. It's something that I think James Merralls would have been very proud of, and I should also mention how the Merralls Fellowship came into being. It started with the vision of Philip Crutchfield KC and was launched by the late Joseph Santamaria KC. The early founders and supporters of the Merralls Fellowship included Chief Justice James Allsop AC, Ian Hardiman AMKC, Dr. Gavin Griffith. We had obviously Philip and Amy Crutchfield, Justice John Middleton and Judith Middleton, Justice Mark Mashinsky, and a number of others have been involved throughout the years. So it's a great fellowship every year, supported by a wonderful member, usually of council, someone of note who can speak to this. Now, I want to turn to some questions. I'm going to sit down with Rachel and we've got some excellent questions from the audience. May I invite those of you who wish to add more to jump on the link there with the QR code, and you can add them and they'll appear on the iPad up here. Rachel, I'll come and join you. So the first one we had, which was an interesting question, is if you were PM for a day and had to convene a Royal Commission, what would it be into?
I'm very glad that you told me about this question a few minutes before I started, because I'm going to give an answer which relates to a selfish passion project in a sense, so it probably undermines a lot of what I just said. I would call a Royal Commission into the need to consider, and I just want to advertise what I think the result should be, whether we need to urgently introduce universal, high-quality, free childcare for every child in Australia for two reasons, principally. The first is that the situation of women and their participation in working life and the economy will never change until that happens. We can talk about it forever, but that's what's needed. And the second thing is that particularly in the post-COVID world, I'd already seen this research, but it is now absolutely in. Children, the declining rates of literacy and difficulties with social engagement, empathy and screen time and all the rest, they need to be in high quality childcare from the age of 3, 4 or 5 if they can be. And for that reason, it would be a bit of a setup, but I would like to have a Royal Commission into that. And it could then explore all kinds of things, including, as the Productivity Commission has found many times, that the more that women can participate in the workforce, the better it is for the economy. And it can also look at the educational attainment and other gains for children. We don't need a Royal Commission for that, but if I were Prime Minister for a day, that's the one that I'd establish.
Now, Rachel, on the back of that, a great question. Should we compel the adoption of recommendations from Royal Commissions?
No, I don't think we should compel it, and it would be difficult to do so, but I do think something like the Bushfires Implementation Monitor, and I think other Royal Commissions have now started doing the same, is vital, because otherwise you get the phenomenon that I described in my remarks, namely the government has a few public servants who are in charge of sort of listlessly monitoring whether or not things have been implemented, and they have nice charts with ticks. A lot of them are often partially implemented and you're never really sure what that means. If you have a statutory office holder whose job it is and who will usually come from a background with some expertise in checking whether it's been adequately implemented, I think that would be a really good way to go, rather than assuming that every recommendation should be implemented and should be required to be implemented. One example that sort of somewhat chills the spine for me is one which comes from the Luke Batty inquest that I referred to. That was an excellent inquest which issued a number of really important evidence-based recommendations which the Victorian government then set about implementing. And many of them, on behalf of Ms Batty and all like her, I was very attracted by, motivated to want to see get done. But one of them involved a change to the Bail Act. And years later it's been reversed because the unforeseen consequence of changing it in a way that was designed and genuinely intended to ensure that men who were flouting intervention orders and breaching their bail conditions, that they would be dealt with differently. The unintended, horrific consequence was an increase in the incarceration rate of Indigenous Australians. And so that's been wound back. Now this, I think, shows up one of the problems, and that is lawyers are not subject matter experts. We skill ourselves up to be able to cross-examine and to make submissions about subject matter, but we are not subject matter experts, nor are coroners, nor are royal commissioners. They come to know a lot about it, but we're not the experts. If there were a system where prior to recommendations being made, or perhaps more logically and efficiently after, but if there were then convened a round table of experts at 6 months or 1 year or 5 years to look at, have these recommendations been implemented, and have any of them gone wrong? Are there unintended consequences? Then we could redress some of the problems. But what that, I think, really shows up is this. If politicians were doing this work, there would be the police or the Minister for Police in the room saying, hang on, if you change that, this will happen. or the Attorney General's staff would say so. And others who were tasked with advocating for victims would say the opposite. And then the government would work out what was the best way to go for its community. But when we shift all of this off to those of us who are experts in law but not in policy, sometimes there will be overcorrections that then need to be fixed.
Can I ask on the back of that, I mean, it seems like the roundtable concept is a great one in terms of getting stakeholders who would be affected by the recommendations to the table. But does it mean we'd have a Royal Commission on a Royal Commission effectively and prolonging the whole
There's a
palaver?
risk of that, and that's why I think doing it before the recommendations are made is too cumbersome. Making it or permitting it to happen as a sort of a review function I think could be useful. But it just really underscores my first point, which is governments are supposed to make policy. Courts and commissions are pretty good at working out how and why something's gone wrong and suggesting changes. But it really is a strange situation we've landed in where these reams of recommendations then become a substitute for the policy interrogation function that governments used to undertake.
Now, you mentioned just there the inquest you're involved in. You also mentioned public inquiries. Do those other processes have a role or should have a greater role rather than royal commissions?
I'm in two minds about that. I mean, in both a Royal Commission and an inquest, the people who are principally at issue, the victims, have no capacity to set it up, no control over it, but often benefit from it being run. They may need to pay for lawyers if they haven't got pro bono counsel to be involved, but they certainly won't have a cost order made against them. So there is that benefit. Sometimes an inquest can be a very efficient way to find things out. And there have been many inquests that have then been replicated by Royal Commissions, which is a shame. There are also other inquiries that we're all familiar with, you know, Senate committees and other parliamentary inquiries. Some of those do very good work, but you can never be sure, and we can never trust, I suppose, that there aren't party political influences that are inspiring the topics or even the very questions themselves being scripted by combatants in the political sense. So there is a place for a Royal Commission, which are always presided over by expert decision makers and listeners with a huge degree of skill and intellect. But, you know, there are the other problems that I've pointed to.
I've got a question from Peter Willis SC, who I think was an early supporter of the Merralls Fellowship, and it's a great question. Is not the function of a Royal Commission often like a corporation engaging external management consultants such as McKinsey or others? Although the answer may be obvious, the external source of that advice simplifies the adoption of the recommendations.
I think that there's a lot in that. So, you know, my complaint or criticism that sometimes we know the answer perhaps dovetails into what Peter's asking, and that is you may well know the answer, the government might know the answer, many people might know the answer, but there might be trenchant criticism or opposition in the community who don't yet believe or accept the answer, who need to see it and hear it for themselves. The trust that Australians clearly place in Royal Commissions and Royal Commissioners means that perhaps there's a need to go through the process. And I have also experienced that myself. When the Royal Commission into Institutional Sex Abuse was set up, I thought and said to many people, we don't need it because I am willing to take it as read. These horrific crimes were committed. Let's move more quickly. Let's start prosecuting. Let's start penalising. Let's start removing the charitable status of schools that are unable to promise that they've improved circumstances. I want to get on with it. Then I started seeing and hearing the stories of victims, either in real time or in press reports, and realised, first of all, the profound importance of them having that opportunity, the incredible educative effect that it had in the general community. And this is only anecdotal, it's not my place to say this. I don't do criminal law, but it seems to me it is very likely that Royal Commission's educative effects include changing the minds of our judges and our jurors in relation to the matter of consent and in the way in which stale, excuse that term, but stale or old complaints of sexual abuse are brought forward. It seems to have played a role in a fundamental change in Australians' appreciation of those phenomena. And therefore, I am also happy to say, and have said many times, I was wrong about that. That was one of the important purposes served by that Royal Commission.
And on that, we've got a question from Maria O'Sullivan about the role of victim-centred truth-telling and that aspect of Royal Commissions, and whether a truth commission would be better suited for some recent Royal Commissions in some cases to carve off that role that's currently heard in Royal Commissions.
Possibly. I do want to say, this is very pedantic, but I wish we would stop calling them the witnesses who are giving evidence about lived experience. All experience is lived, but anyway, that's just a pedant's complaint. I think having both can be really useful. So in the Bushfires Royal Commission, at 2 o'clock every day, a victim gave evidence. And it was really important because it was a really different way of approaching things, rather than saying, well, this week is going to be the victims and people might tune out and not watch, or only watch that bit and not watch the other bits. It was earmarked that it would be at 2 o'clock every day. But I came to hear or overhear that there were those in the press gallery and those who attended regularly who called it 2 o'clock tears, which was obviously a pretty demeaning way to describe it. It didn't change my view that it's important, and I think if you're going to have it, I think it remains best to be dealt with in the running of the Commission, not relegated to a special project. There might be good reason to put it in a different category, not live stream it, or perhaps stream it on delay so that any very personal matters can be taken out of the broadcast. But I think it is better to have it injected in the proceedings. But it's a difficult line to walk, because what's commonly done now is that those witnesses are not permitted to be cross-examined. And I have to say, it does lead to a lot of genuinely heartfelt, well-intentioned evidence being given, which is sometimes misinformed and then creates its own problems because it's not tested in cross-examination. So there is a real tension there. I'm not sure what the answer is, but I think if we just hived off victims' experiences to another whole process, that would very much devalue them and very much create a second rung or a second tier sort of a system.
Now, we've got a lot of questions and only time for a couple more. I've got one here from Jackie Fristicky. Has trust in Royal Commissions replaced trust in government?
To a large extent, yes. And, you know, there are good reasons for it, because our Royal Commissioners, the individuals who they are, and the office or role that they have usually typically held, former judge, means that they are people of, you can be sure in Australia, people of high calibre, beyond reproach, uncorruptible. I mean, that's what the Australian judiciary is. So there's a good reason to trust them. And also they have runs on the board. Royal Commissions have shown themselves to be meticulous, courteous, civil, forensic, compassionate, and also very skillful. So there is a very good reason why Australians trust them. And I might say, not just to promote the Victorian bar, but barristers, like all Australian lawyers, tend to also be civil, courteous, and so on. And so when people watch the proceedings, they have a feeling that the subject matter is being treated with care and respect. When they watch parliamentary debates, I don't think they necessarily feel the same thing at all. So, and they feel that compromises are being made, and they might understand, and we probably all do understand why they're being made, but it really doesn't feel like the central problem is being privileged in the way that careful judicial legal analysis does. So I think that's probably sadly the case. It doesn't need to be that way, it shouldn't be that way, but unfortunately the calibre of political debate is very poor, and the capacity, although it's a very set piece, the way in which problems are dissected in a courtroom or in a Royal Commission is often better informed and certainly more civil.
Now, a final question we have from Shane.
I know people are laughing, they probably want to say, except if I'm on my feet, but... Yeah.
This question from Shane. As evidenced by current Royal Commissions, having clear terms of reference is essential for achieving efficient outcomes. I know you mentioned the Financial Services Royal Commission and then also the Longford at the other end. And they gave us some insights into what you consider are useful and efficient terms of reference. Can you expand on that?
Perhaps by using the Esso Longford Explosion Royal Commission terms of reference as a guide, that ran at a great pace and was very efficient, partly because that was the habit of that former judge, but also more in keeping with the times. But it was partly because the terms of reference were rigorously adhered to. Every wretched time I got to my feet, His Honour said, "What paragraph are you cross-examining in relation to, Ms Doyle?" And I had to continually engage in a lot of gymnastics to get the interests of Trades Hall, and it was to a large part, for a large number of the questions or topics I was pursuing, it was something that the United Firefighters Union had asked me to ask, or that the Public Sector Union, who represented the WorkSafe inspectors who'd been there and overlooked some things. And there was a real discipline, and I had to be ready each time. I had to make sure my questions were really thought about the night before and that I was ready with the answer. And I noticed that the same was applied to everyone else around the room. And that habit of His Honour and that habit of the Times of really tying people back to the terms worked. I saw that happen in recent days in the Anti-Semitism Royal Commission as well. But often Royal Commissions now drift miles from the terms of reference. And it's difficult because sometimes they need to. Sometimes new things are... Well, when you draft the terms of reference, you're in a state of not knowing, and so are counsel assisting. When you learn more, sometimes you realise the questions you should ask. But that discipline of tying everyone back is not cruelty or vanity. It's about efficiency. And I saw that done in 1998, and I've never forgotten it, because it is partly why the report was handed down within months of the explosion occurring, bringing some closure to the families of those who died and were injured, and bringing some solutions in terms of the safety of hazardous facilities in Victoria.
Well, let me turn now to thanks. Rachel, thank you so much for your brave and fearless insights into Royal Commissions based on your deep experience into them appearing, assisting, and the follow-on cases that you've been involved in over many years in your career. As to the potential junkies, you identified the three groups of politicians, media, and some lawyers. I liked your causes of 4 nutrients which might embellish make Royal Commissions better in that respect. And I think really looking to those 3 groups, they each serve, Royal Commissions serve different masters and different consumers by them. But I think we can safely say that they're thriving here in Australia. So thank you so much from all of us for your views as the 2026 James Merralls Visiting Fellow in Law. Thank you.